Okay. Hello. I think we're good to go.
Yes. Welcome back, everyone. Kit and I are jumping around between three different hearings over the last couple of days. So just going to refocus ourselves back on our rural provisions. Louise and Todd, you've been involved with us recently again too. So thanks, Denise, for coming on with this right of reply. So do you have any notes or presentations to give us, or are you just going to do it verbally?
We're just going to do it verbally, but I probably am going to look at my screen. So
Yes.
I'll read off my screen and
Yep.
Yeah.
Are we starting with you, Denise, or?
Yeah, if do you want me to just kick off? Okay, I'm going to start and then Louise will do rural lifestyle and then Todd will finish with the future urban. Some of the issues I'll cover will also cover the other chapters, and I'll signal when they cover more than one chapter.
Okay, I'll just get my notepad just a moment. Right.
Okay, so I'm just going to start with some of the questions that both the commissioners asked me on the first day. Commissioner Daesh, you asked me around why does mining make up 10% of all rural business units? I can confirm that the definition of mining rural business units includes oil and gas exploration and processing. And given that Taranaki is the only region with oil and gas exploration, that would account for why it's 10%. The next issue was clarity. You asked, Commissioner Daesh asked clarity around the decline in consents for the erection of buildings from 2013, and was this the result of plan change, the adoption of plan change 27? I have yet to sort of investigate that, and I'll supply that information in my written right of reply. Commissioner Daesh, you asked also, requested clarification as to the minimum building setbacks for shelter belts. Again, I will address that in my written right of reply. There were two matters that Commissioner Daesh, you asked me to confirm scope, and they relate to a change I recommended at the top of page 137 of my section 42A report, relating to some matters of discretion, and also the inclusion of stockyards in effect standard S2, which is minimum building setbacks. Again, I've discussed these matters with Ms. Wallace, and I will address this in my written right of reply. Commissioner Littlejohn, shall I just keep going? Is it okay? Okay, all right. Commissioner Littlejohn questioned me around the use of the term plan character in the rural production zone. In my section 42A report, in response to a submission from Kaionga Ora, I've replaced the term dominant character with the term plan character in 16 provisions. In my written right of reply, I will reconsider whether the term plan character is appropriate in a rural setting, where the objectives of the chapter are seeking to maintain rural character, which is a defined term, which is separate from the planned role, function, and urban form of the zone. I'll now just turn to matters that have been raised in evidence. The first matter is the keeping of goats, and I'm going to talk about this matter, and it applies to all of the 3 zones. First of all, I would like to thank all the submitters, especially Ms. Benson on behalf of Ngāti Mutanga, Ms. Walker on behalf of Federated Farmers, Ms. Gibson on behalf of Project Maunga, and Mr. Coombs from the Department of Conservation for the time they've taken to explain the practicalities of keeping goats in the New Plymouth district. Commissioner Littlejohn requested information relating to the number of resource consents for the keeping of goats as a controlled activity under the operative district plan. I can confirm since the year 2000, the council has not issued any resource consents for the keeping of goats pursuant to Rule RU17. In my written writer reply, I'm going to address the following matters. I'm going to confirm whether the term the keeping of goats has a clear and natural meaning. Consideration as to whether a controlled activity status as put forward by the Federated Farmers controls the risk of domesticated goats escaping into Te Papakura or Taranaki, especially given the potential of a goat-proof fence failing due to a tree fall and then goats escaping into the park. If a restricted discretionary activity is considered appropriate, I then need to consider the evidence provided by the Department of Conservation as to whether an advice note should be added around who would be considered an affected person in relation to the rule. I note that Ms. Macbeth, in her written writer reply on the Eco chapter in Hearing 5, did not recommend the plan adopt notification statements. In my written writer reply, I will also have further consideration as to whether the 2 kilometres of the keeping of goats rule, and hence the spatial layer, should apply to Paraninini and the other 2 areas outlined in the evidence provided by Ngāti Mutanga. And in considering this, I will be looking at the workability of this provision, and in terms of workability, I'll be looking at acknowledging the level of current goat control in those areas, the funding for the ongoing goat control, and whether goats are farmed in any way on the adjoining land. I will also,
Denise, on that one too, you're
Yeah.
going to talk with Doc, I think, about just the area that is specified in the Mount Messenger resource consents and designations when, assuming that gets finally through the courts, just to match up the area that will be under constant predator-proof predator management if that project proceeds.
yes, that was my next point.
Okay,
sorry, I was going to confirm with Doc the spatial area of Paraninini, and I was going to raise those matters about the work that my criteria about workability would, be more favourable if it was the area that was going to receive the ongoing funding.
Yes.
So I'm concerned. Also, I'm going to look at the drafting improvements of the controlled or artist rule, as pointed out by Ms. Johnson, to ensure that the keeping of goats outside of the 2 kilometres spatial layer does not have to comply with the effect standard in relation to goat-proof fencing. I consider that the heading of the rule could be changed to clarify that. So I don't think the rules, as it's notified, is drafted quite correctly. It's still a little bit ambiguous. So I'll probably work with Ms. Wallace in trying to get the drafting of that rule clearer. In a consequential amendment, I did notice that the Department of Conservation, in relation to FUS R11, also has a keeping of goats rule. I note that it's the view of DOC that FUS 11 is not needed, but I do note that this spatial goat control layer extends into the Uakura FUS. So I'll be looking at either the idea would be we remove it and then we would have to alter the layer so it didn't overlap the FUS, or maybe keeping the rule but for consistency making it the same across the same activity status across all zones. Currently, Mr. Whitaker didn't have submissions to change that rule, so it's currently still sitting as controlled. So that's all I have on the keeping of goats. If anyone has any further questions.
Not for me. I think it's pretty comprehensive, Denise. So just perhaps move
Okay.
on.
The next topic is providing for horticulture and horticultural structures. So I would like to thank Ms. Landers, who was acting on behalf of Horticulture New Zealand, for her very thorough analysis on how the other district plans provide for horticulture activities. I found this very useful. I've been doing a little bit of research in terms of what's sort of happening with horticulture activities in Taranaki. Venture Taranaki is currently funding a project called Branching Out as part of its future food strategies, and is looking at the following crops. So avocados, gin botanicals, grains and legumes, hemp fibre, hops, indigenous ingredients, kiwi fruit, and medicinal herbs. Other studies undertaken by Venture Taranaki, as referenced by Ms. Landers, also indicates that apples may also be a viable crop in Taranaki. Ms. Landers stated that both hops and kiwi fruit require crop support structures. I consider that the rules proposed by Ms. Landers in relation to the setback from boundary requirements for artificial crop protection structures and crop support structures have merit and would future-proof the PDP. In relation to standard S6, the maximum gross floor area of a building, which was raised by Horticulture New Zealand, I'd also like to note that a further submission lodged by NZ Pork was in support of Horticulture New Zealand and also opposed the 250 metre standard for all other buildings. So that's buildings that are not covered by the other standards within S2. So they include like a fruit stall or intensive indoor farming, so a chicken farm or an indoor pig farming. They argue, NZ Pork argues that the rural production zone is designed for rural production activities, which by their nature will generally be larger buildings. I note that the operative district plan contained a larger maximum gross floor area of 400 square metres as a permitted activity for non-habitable buildings in the rural zone for sites under 4 hectares. And in the operative district plan, there were no controls for non-habitable dwellings in rural zones of sites over 4 hectares. I will seek expert advice from Mr. Richard Bain, who is a landscape architect, in relation to whether buildings associated with horticulture activities, for an example, greenhouses, should be excluded from the maximum gross floor area, and whether the approach in the ODP or other agricultural buildings has been effective in managing the adverse effects. I will report the key finding of Mr. Bain's work, as well as discussions with the resource consent team as to the effectiveness of the effect standard S6 is notified in relation to the 250 square metre limit associated with agricultural, pastoral and horticultural activities. Any questions?
No, that's all fine. Carry on.
Provision for energy activities is my next topic. The evidence of Ms. Callan on behalf of Trust Power, Ms. Carville on behalf of Greymouth Petroleum, Mr. Twigley on behalf of OMV and Todd Generation Limited focuses on the need to provide specifically for energy activities in the rural zone. The basis for this request is to provide more certainty and clarity that energy activities are an anticipated and accepted part of the rural production zone, and or that energy activities have a functional and or operational need to be located in these areas. I feel that the PDP acknowledges that energy activities are part of the rural environment. However, there are a range of activities which are part of the rural environment but not explicitly referred to in the objectives and policies in the rural production zone chapter. These include, for example, network utilities, infrastructure, earthworks, and the subdivision of land, which are not explicitly referenced in the rural production zone objectives and policies, apart from where there is a specific rural issue to be addressed. The objective and policy framework for these other activities are contained in the relevant district-wide matter chapters in the PDP. The objectives and policies for the zone and the district-wide matter chapters in the PDP need to be read as a whole. In my view, this approach avoids duplication and provides for an effective framework for all types of activities. However, in saying that, I do recommend a minor change as suggested by Ms. Carville in relation to objective RPROZ04 matter 4, just a reordering of it. She suggested that energy activities is put first to clarify that they are not part of rural industries. And I'll report this back. I will show you the change in my written writer reply. I take the point as set out in paragraph 25 of Mr. Twigley's evidence on behalf of OMV, that while my section 42A report has addressed the issue of not wanting to duplicate the provisions of the energy chapter in the rural zones, which the evidence of Ms. Carville agreed with, it is silent on the issue of consistency between the energy chapter and the rural zones. I consider that the issues of duplication and consistency are interrelated, and therefore stand by the recommendations in my section 42A report and recommend no further changes to provide for energy activities in the rural production zone apart from the change I've just outlined in relation to the evidence put forward by Ms. Carville in relation to objective 4. Any questions?
Thank you. No, keep going, I think.
My next topic is in response to evidence presented by Ms. Helen Johnson. And this response covers some general matters in relation to both the rural production zone and the rural lifestyle zone. Firstly, I'd like to thank Ms. Johnson for a very thoughtful analysis as outlined in the evidence in chief. The reporting officers of the rural and residential zones have met prior to the hearing, and we find Ms. Johnson's argument to remove rules RPROZ R36 to R42 and rural lifestyle rules R30 to R35 and their corresponding rules in the residential zones compelling. The rural and residential zone report writers in light of the evidence presented, will assess both options presented by Ms. Johnson, and the options are either the deletion of the rules and retaining just 2 rules, one saying that building activities are permitted and one addressing relocated buildings, or 2, the adoption of the amendments proposed by Ms. Johnson in her Appendix 1B. Just to clarify, it's the opinion of all the reporting officers across the rural and residential zones that some movement is needed on these rules. In addition, I've spoken to Ms. Edwards, and she agrees that the matters addressed in Ms. Johnson's evidence in relation to plan consistency as to how different zones address whether height in relation to boundary applies to buildings only or buildings and structures provides thoughtful observation. As these matters have been and will continue to be addressed as consequential amendments in the zone chapter reports, it will be prudent for all the recommendations to be summarised and checked for consistency as part of the final plan change integration hearing.
Thanks for that particular point, Denise, because Ms. Johnson was talking to us again today in the context of hospital and airport special zones. So we just, I think, had a chat with her that that seems to be a plan-wide issue, and we agreed. So if that's on yours and Sarah's radar to bring all together at that last hearing, that would be great. Yep. Right.
Okay. On to the submissions from New Zealand Pork. Firstly, I'd like to thank New Zealand Pork for their very detailed evidence that they provided in relation to the different types of pig farming. Mr. Is it Brough? Sorry if I can mispronounce his name. And responding to a question from commissioners, stated that indoor intensive pig farming is more suited to the climate of Taranaki, and the main reason for this was that we have high rainfall, and that intensive outdoor pig farming is more suited to areas such as Canterbury, which has lower rainfall, which enables farms to easily retain vegetated cover. I consider that the plan adequately provides for indoor intensive pig farming under Rule RPROZR 12, where intensive indoor primary production is a restricted discretionary. I note that NZ Pork submission supports this rule and requests it be retained as notified. So the matters I will report back on in my right of reply in relation to the evidence from NZ Pork are around the need for new definitions, and the new definitions relate to intensive outdoor primary production (pig farming) and extensive pig farming. I will also need to consider how these definitions would fit into the rural primary production nesting table. I will also consider whether Rule RPROZR 12 needs to be amended or a new rule drafted to provide for intensive outdoor primary production pig farming. And as noted, NZ Pork accepts it's appropriate for this also to be a restricted discretionary activity. I will also, in my written right of reply, do a check of consistency with the terms used across the chapter in relation to intensive primary production, noting that I recommended the deletion of the PDP notified definition of intensive primary production, and had preferred, and the plan had recommended that the plan use the the NZ Planning Standards definition of intensive indoor primary production. I will also consider the evidence presented by NZ Pork in relation to FEC standard RPROZ S6, which is the maximum gross floor area, and whether there should be an exemption for mobile pig shelters. Again, I will seek the expert advice of Mr. Bain as to the effects of numerous smaller buildings being scattered over the landscape. That's the end of the discussion about from NZ Pork. Are there any questions?
Denise, was really just a question about whether you think all those different definitions, or just whether they're going to, I suppose the aim is to make things as clear as possible, and definitions do help with that. But there seems to be 3 or 4 definitions that might apply, and some new ones, and
I suppose in my section 42A report, I realised there was a problem when I looked at the definitions. There was just a problem as to how we didn't quite because we don't have a lot of piggeries, and they do tend to be, I think in the evidence they said we have two, and they're both indoor.
Yes.
That these aren't things that we probably deal with, and so the plan doesn't have any definitions. But I do feel like the definition for extensive pig farming is really covered by the keeping of livestock. I suppose my main concern would be, I have suggested in my section 42A the use of the term outdoor pig farming, and whether that's very clear. It's in a nesting table, and it differentiates between, that great piece of evidence where so that the type of pig farming that we have is the animals are kept indoors their whole life cycle, and they never go outdoors. So I suppose it's just providing some clarity whether, I agree with you, whether having a definition for outdoor pig farming would, what is that?
It's a question about whether that covers like the old indoor outdoor lifestyle with these mobile shelters where they do have somewhere to sleep, and then they come outside, and so it's quite a fine issue, isn't it? So good luck with working your way through that.
Great. Okay. The next group of submitter was that I wanted to talk about was the New Plymouth Airport. I'd like to thank Mr. Edwards for bringing to my attention the council's recent purchase of the land adjacent to the New Plymouth Airport. I note that the commissioners have requested Mr. Edwards to supply the following information: submit a legal submission as to the scope of the phrase properties between Area Q and the airport, provide a copy of the airport's master plan including new noise contours, and confirm the name of the previous owner of the land, which was recently purchased by the council. I've been in discussions with Mr. Edwards about these 3 matters earlier this week, and I can confirm that Ms. Ongley will provide legal submissions on the scope issue on the 24th of March. Mr. Edwards has provided me a copy of the airport master plan, which shows the new noise contours, and council has provided the name of the previous owner to Mr. Edwards, and I understand he's passed that on to you, the commissioners. So once the matters of scope, I need to understand what areas the rule. So Mr. Edwards suggested a restricted discretionary rule. I think we need a clearer understanding of what areas or properties that would apply to. And once the issues of scope have been resolved, then I'll work with Mr. Edwards to get some kind of joint agreement. I don't know if we'll reach an agreement, but at least we'll have a joint understanding of the properties and the nature of that rule. The other point raised by Mr. Edwards, I need to do further work to understand the plan-wide implications of his proposed change to RPROZ P7 to include noise contour boundaries, noting that there are noise contour boundaries for other activities in the plan.
Yes, I think that's important, Denise. Just that those knock-on effects potentially with that suggestion.
That's the end of my comments on the airport submissions. The next lot of submissions are from tangata whenua. I'd just like to thank the iwi submitters for the evidence. I found it clear and helpful, and it highlighted the gaps in providing for Māori purpose activities and tangata whenua's presence and relationships in the land contained in the rural production zone, especially in objective RPROZ04. I accept the submissions from Ngāti Rahiri and Ms. Bellamy on behalf of Te Atiawa to add the phrase marine, marae and associated buildings to objective RPROZ04 matter 2. I will consider whether further amendments are needed to the policies to further recognise for tangata whenua's presence in the rural production zone, and I will report back in my written reply on that matter. However, I do not consider that an additional policy is needed in the rural production zone to protect unscheduled biodiversity values, and stand by the recommendation in my section 42A report that the eco chapter policies adequately address these matters, and the plan should be read as a whole.
Thank you. Yep.
That's the end of the tangata whenua submitters evidence.
Thank you.
In one final matter, the final submission I'd like to talk about is the submission from the Green School and also the Ministry of Education. So I'd like to thank the Green School for the significant effort and passion that they put into presenting the evidence. Ms. Wallace and Mr. Grieve have addressed the matters of scope in relation to the precinct plan as outlined in the evidence of Mr. Twigley. I note that Ms. Wallace is considering whether further legal submissions are required on this matter in response to the legal submissions presented at the hearing from Mr. Grieve. However, I do see merit in the evidence presented from the Ministry of Education and the Green School that schools should be better provided for in the rural production zone, recognising that there are approximately 10 existing schools in the zone. I will consider in my written reply whether a discretionary activity status would be more appropriate than a non-complying activity status in relation to educational activities in the rural production zone. That's the end of my, yep.
So you didn't have anything further to report about the Green School's submissions and evidence about residential activities, Denise?
No, I just think that the matters of scope, that they're sort of matters of scope.
Yes. Their point was pushed pretty hard in the evidence, and wonder whether Lauren, I see you're there online, whether you thought any more about whether you can provide any more assistance over and above what you've provided with us already on that. It's a issue that Kat and I have talked about after the presentation was given to us by the Green School, and yes, whether anyone could fairly, looking at the submission, anticipate that up to 90 houses might be provided for in a positive way on that land. That's the key issue for us, I think.
Look, I haven't given it too much thought since Friday. I've been in Wellington the last 2 days, but I think for me the issue is the precinct plan. That predetermines the location of activities, and by virtue of its introduction, the intensity and scale of activities. And whilst the proposal was for discretionary activity status, having those words in the plan gives the expectation that that's what's expected there, and that hasn't been assessed in any real way, certainly not by the council, and that hasn't had, I don't believe submitters have had the opportunity to even contemplate that. So whilst there may have been an indication that residential activities may occur on that site in the future, I don't know that anyone, I'd like to just do a little bit more thinking around that. But
yes, certainly we left it. I think that you would have a think about that, but any assistance you thought you could give us on that would be helpful as always. Thank you for that.
Stephen, can I just jump in and
yes,
have a bit of a chat about this? I mean, there really are two issues. There's the preliminary issue, which is around scope, and I think, I think Lauren's raised the valid point that certainly the council didn't conceive of this concept and do an assessment of it. So that's, I guess that sort of supports the no scope argument. So that's the first bit of it. The second bit of it is, I guess, to ask the hypothetical question: what if the Green School's submission had specifically sought an opportunity for residential activities at the Green School campus associated with the school as a discretionary activity? What? And I know you haven't assessed that, but I guess I'm asking you on the fly. What would the position be? What would council's overall reaction to that notion be?
in terms of scope or merit?
No. I mean, I'm clear that we've got a preliminary issue in terms of scope. Assuming there was no issue though, and the submission had been clear, Denise, do you have a particular view on this from a planning perspective?
I'm just looking at my section 42A. So I did reject their submission that they asked for residential activities. I'll have to, sorry, I think it's quite complicated in that they're seen as non-compatible because they're residential activities. So in policy P3, residential activities that aren't auxiliary to rural use are seen as non-compatible. So I'm sorry, I would have to check, and that's why I rejected their submission in the first place. But I'd have to check the plan as to whether they're discretionary. That would mean they would be discretionary or non-complying.
If I could just add to that, the request, as I understand it from the Green School, is that residential activities in accordance with the precinct be discretionary. So the two are sort of inextricably linked. If the precinct plan, if the conclusion is that the precinct plan, there's no scope for it, then would it just be that residential activities on the Green School site are discretionary? And then we'd have to examine, I guess, yeah, all of those 32 considerations and whether or not that's an efficient and effective use, and also the precedent that would set for other activities in the rural zone. Because at the moment, the proposal is that residential activities should be associated with rural activities.
Yeah. Okay. No, yeah, that makes sense. All right. Yeah. Yep. Okay. No, that answers the question. Thanks.
Thank you, Lauren. Again, we'll leave it open about whether, as part of the right of reply, you do provide something additional in terms of any legal submissions.
Cool. Yeah, I mean, yeah, there's a lot of case law around scope. I think you said, Kit.
We've seen it. Yes. Yeah.
It's a difficult question, and you know, you don't want to be overly legalistic. So if there is scope, certainly we'll then, you know, move past that point. But yeah, it is an important point because it may unfairly prejudice other people.
Lauren, it wouldn't be unusual in your travels to see a submission on the lines of a submitter putting in something like that precinct plan with their submission and requesting that be put into the plan. You would have seen that before.
Yes. Yeah.
Plans and,
I guess for this one, when you go back and look at the original submission, it really only sought some changes to the policies, and then a couple of, you know, that did it even request a change to the rule? Sorry, it's been a little while since I looked at it.
I was more talking about there as an original submission.
Oh, right. Yes.
It's quite common for people to put in quite detailed requests.
Yes. Yeah. Absolutely.
Along the lines of the precinct plan, and that was available. That didn't happen.
That's right.
We've got this issue of grappling with scope and trying to second guess what might have been intended by the submission, and then it's certainly there's been some backfilling coming along in evidence. So that's the yes.
And certainly with the other precinct plan, I think we discussed this, but a huge amount of work went into those. So, you know, there was an indication from those activities that they were desirous of them. And so, you know, there was a lot of work that went on around that to get them plan ready.
Okay. Thank you. Denise, was there a submission that was asking there? I think, was it the discretionary status?
Memory, I think they didn't submit on the rules themselves. They submitted on the policies.
Yes.
So they submitted on P3 wanting residential activities in relation to the Green School to be potentially compatible and not incompatible. So they didn't submit, from memory, didn't submit on the rule.
And Ministry of Education didn't seek discretionary?
The Ministry of Education sought discretionary for educational facilities.
Yes.
Which I've agreed that I will consider.
Yes, but not obviously they weren't looking at residential.
No.
Okay.
So I've got the submission open. So there was a submission for the rule 33 to change for educational facilities, but there was nothing in there about residential. So the only reference to residential was in respect of the policy.
Policy, yes.
But you know, I do got the point that there needs to be a method that would then flow from that. So you could, there could be an expectation of that. So it may be that, including residential as a discretionary activity could be within scope, but then how does that tie into the precinct plan?
Yes, and we've got other examples of sort of reasonably broad requests needing to be, to make them work, needing to be filled out with detailed provisions around rules and standards and all those aspects, haven't we?
Mm.
Yes. Okay, that's probably about as far as we can go with that. Thank you, Denise, and thanks for having that discussion, Lauren.
Yeah, no problem.
Thanks, Lauren.
Okay, that's the end of the rural production zone. Onto rural lifestyle.
Thank you. Is this Louise now?
I'll start on the rural lifestyle zone.
Thank you.
Again, I'm turning my head to read off another screen, sorry. So in response to the specific questions the panel has directed to me during the hearing, the commissioners have queried whether the rural lifestyle rezoning simply reflects historical land use pattern, or whether there is yield subdivision development potential to develop the rural lifestyle areas. As part of the district plan review, analysis and testing was undertaken in order to establish the yields through different subdivision scenarios. The result of this work has been the rural lifestyle subdivision parameters that are proposed in subdivision rule sub R3. So in summary, subdivision in the rural lifestyle zone is a restricted discretionary activity where no more than 4 proposed allotments being created have a lot size of less than 1 hectare in area. Every allotment has a minimum lot size of 4,000 square metres, and for each allotment that has a size between 4,000 and 1 hectare, a corresponding 1 hectare balance is provided. So bearing this in mind, the yield has been calculated in 2 different ways. So we have 2 different scenarios. The first scenario calculates how many 1 hectare lots have been subdivided in each rural lifestyle area. And the second scenario calculates how many 4,000 square metre sections with a 1 hectare balance can be created as per the subdivision rule sub R5. So based on these parameters, there are between 104 and 181 subdividable lots across the rural lifestyle zone. Scenario 1 creates the 104 lots, and scenario 2 creates the 181 lots. So it's important to note that this yield calculation is not a total of what land is already available. For example, a clear site around 1 hectare in size is available and already subdividable for rural lifestyle use in some of these rural lifestyle zones. The calculation in this first scenario does include some existing rural lifestyle land, for example, the 1 hectare balance. Therefore, bearing all this in mind, a second lot of calculations was undertaken, and this work was done to show how many sections are existing in these new rural lifestyle areas that would be already at lot size as provided for under subdivision rule R5. And for this exercise, we looked at how many sections each rural lifestyle zone contained that were less than 14,000 square metres in size. So I want to reiterate here again that all rural lifestyle areas notified in the proposed district plan were assessed and selected based on the criteria in the Rural Lifestyle Zone Section 32 report. They reflect either historical lifestyle subdivision patterns or where primary production land is suitable to transition to rural lifestyle. And both these scenarios provide for some subdivision potential. I could, if you would like me to, go through the different yields and show you what each area has in terms of subdividable potential and existing lots that are already at a rural lifestyle zone, or the other option is I detail that further in my written right of reply.
I'd be happy for you to do that in the written right of reply, Louise. Kit?
Yeah, I'm happy with that. Is there a headline that you can tell us though, in terms of across all of them?
Well, the way the analysis is broken down is into each area, and then there's the total. Okay. But I guess the main point is every lifestyle area has some land. Every lifestyle area has subdivision potential in terms of further yield, and every rural lifestyle area also has existing section sizes that would meet the rural lifestyle lot size. So there's a mixture of opportunities. There's some that could be on the market tomorrow because they're already there and already that size, and then there's the potential for subdivision as well.
Okay, well, I guess I'll wait and see what comes through when you put it all in writing. Might be easier.
Yeah, sorry, it's a bit hard without you actually seeing this table for me to explain it. So it probably is easier in the written right of reply. Okay, the other question posed that was raised by the commissioners, Commissioner Littlejohn raised the issue as to whether the term plan character is applicable in the rural production zone and the rural lifestyle zone. So in contrast to the rural production zone, the rural lifestyle zone is a new zone with plan character from the outset, and it does deal with a type of urban form. Therefore, I believe the use of the plan character in the rural lifestyle zone is an appropriate term.
Okay, yep.
Yep, keep going. Okay, so now I'll move on to the issues that were raised by evidence. And as Denise has already discussed, she has covered the matters that overlap between our two chapters. So I will just deal with the rest of the matters for the rural lifestyle zone. So the first piece I would like to discuss is the evidence from Hapu and Iwi. I would like to thank the Hapu and Iwi for the evidence. It was very clear and helpful. I acknowledge the points that have been made, and I would like to consider these further, and I will report back in the written right of reply. Now moving to the evidence from Helen Johnson. Like Ms. Young, I want to thank Ms. Johnson for her thorough analysis. And as Ms. Young has already addressed the common matters, I would just like to talk to a couple of the matters that are relevant to the rural lifestyle only. The first bit I would like to talk to is in relation to the height in relation to boundary and setbacks under RLZ S2 and S3 under the consequential changes. Ms. Johnson acknowledged in her speaking evidence that in light of the rural lifestyle zone addendum tabled on day one to the hearing, her comments made in her evidence in chief to these provisions no longer apply. So I will take these points to be no longer in contention. The next bit I'd like to move on to was the diagram that is missing under RLZ S3 height in relation to boundary. Firstly, I'd like to thank Ms. Johnson for clarifying which effects standard she understood was missing a diagram. And now we're clear on which effect standard we're referring to. I would like to say I concur with Ms. Johnson that our RLZ S3 should include the diagram as per the same effect standards in other chapters, which all include the diagram. This missing diagram is just an oversight in the rural lifestyle zone. But before I move on, I would just like to raise the fact that the original submission referred to effect standard RLZ S4 missing a diagram, not RLZ S3. However, I believe this is a minor amendment, which we could deal with under Schedule 1, Clause 16.2 of the RMA.
Yes, so if you could just obviously give us that, that sounds pretty clear advice. That's important to come from you as a planner. So thanks, Louise, for bringing that forward.
The next bit of Ms. Johnson's evidence is in relation to living activities versus rural lifestyle living activities. This was addressed in Ms. Johnson's written evidence, but not in her verbal evidence at the hearing. But I just wanted to raise this point. Ms. Johnson queried living activities versus rural lifestyle living activities used under RLZ R30 relocation of a building. Ms. Johnson raised the fact that it would have a consequential impact of making this change, and it would exclude garages, sheds, silos, barns, greenhouses, etc. from being a permitted activity under this rule. I would just like to state that I agree with Ms. Johnson, and this was not my intention by making this change, and therefore I'd like to signal that I'll be changing my Section 42A report recommendation and reverting back to living activities as was notified under RLZ R30. Right, I'll move on to Mr. Hendry, sorry. I would like to thank Mr. Hendry for his evidence. I acknowledge his point of view, but I consider the wider consequences of allowing 2 dwellings would potentially recreate the situation that was occurring in the rural environment pre-Plan Change 27, where the district was experiencing increasing housing and subdivision of rural land near urban boundaries, resulting in land fragmentation. Ms. Young and I have discussed this as this matter goes across both the rural lifestyle and the rural production chapters. And Ms. Young and I both agree with this position, and therefore we both stand by our recommendations to reject this submission across both the rural lifestyle zones and the rural production zones. Lastly, I'd like to move on to federated farmers. I would like to thank Ms. Walker for her evidence as outlined in her evidence in chief. I acknowledge Ms. Walker's request to consider changing the name of Keeping of Goats rule heading from Keeping of Goats to Goat Farming under RLZ R11, and also a corresponding in the Rural Production Zone RP ROZ R9. This change will be considered by Ms. Young, and any consequential amendments will be applied to across to the Rural Lifestyle Zone under RLZ R11. That was all I had. If you've got any questions.
Nothing further from me, Louise, but Kit?
No, nothing further. Thanks, Louise.
Thank you. Todd?
Thank you, Commissioners. In terms of the fuzz matters, actually that fuzz hearing seems like a long time ago now with everything that's been happening over the last few days, but I had 6 matters which I would like to address in the right of reply, and some of this is just an update and will be covered further in the written right of reply. Those matters being fuzz policy P7, the new policy fuzz P8. We had some discussion around some further information and background which may be useful to the Commissioners. Co-housing, consequential changes, and just some other comments in terms of the hearings process. So those are the topics I'll just address in the verbal right of reply. So first of all, the policy fuzz P7, that's the policy which essentially sets out the framework for what will be needed as part of a plan change and structure plan process. There was 2 matters that were raised with respect to that policy, essentially whether or not that policy contemplated a partial staging of development within the fuzz area. My view is that generally the fuzz anticipates development across the whole of the fuzz area. However, I think it's important that the policy doesn't preclude a partial development of any fuzz area. However, I think a high threshold is set, and that's appropriate. Subclause 5 of the policy P7 refers to future servicing needs, and subclause 6 also acknowledges a staging approach. So my preliminary view is that the wording of policy P7 is generally appropriate. However, we can address that further with any directions of the commissioners, and I think we'll probably come back with a little bit further analysis on that as well. The second part of policy P7 relates to the matters raised by Te Ariawa and the hapu submitters in relation to the wording of the specific policy around tangata whenua input, and in particular reference to the expertise of tangata whenua. And as we've mentioned in the hearing, we will go away and hopefully come back with an agreed position on that. I don't think we're too far apart, so I don't think that should be too difficult to achieve that. Do you wish to ask questions as I go through, or wait till the end in your hands?
Let's wait to the end, Todd.
Okay. Next topic was policy, the fuzz P8. So this is the new policy which we have recommended in relation to, I guess, the timing and release of land within the fuzz, and when that plan change process is contemplated. Just in terms, and there has been a discussion around scope on that policy as well, and we will address that in the written right of reply. I don't want to create the wrong impression, though, that we believe the policy was out of scope. Otherwise, obviously, we wouldn't have recommended that. And the rationale for putting that policy forward was in response to the outcomes from the strategic directions hearing. It was also in specific response to the Kāinga Ora submission 563584, although we would need to acknowledge it was an alternate, I guess, response and way to address their submission point. Kāinga Ora have actually said in a very brief written statement that they support the policy. And it was also put forward to recognise the shift from the National Policy Statement on Urban Development in terms of the long-term land supply and how that's defined. So those are the three, I guess, drivers that we put forward in terms of the rationale for recommending that new policy. And I guess just to reiterate, the purpose of that new policy P8 is to establish a policy setting within the fuzz zone to reinforce that development within the fuzz is anticipated to serve long-term land supply, and then this will require a comprehensive and long-term strategic planning and infrastructure response. And at the same time, though, it is not designed to close the door on an early plan change process where this can be demonstrated to provide for a positive land supply and development outcomes for the community. So again, that was the setting that we were trying to achieve there. And just as noted in the hearing, I think it's unfortunate that the commissioners are only essentially going to hear from council planners in relation to that particular policy recommendation. There's been no other planning evidence which has addressed that particular policy. So the commissioners obviously will be mindful of the recommendations from council staff. And I would have actually been pleased to have heard any other alternative perspectives in terms of planning evidence, but obviously that's not going to be available in terms of the deliberations which the commissioners are going to undertake. Next topic, just some further information and some matters that came up through the hearings process. And so I would like to offer to the commissioners that we just do provide a bit of an update on any policy and plan changes that the Taranaki Regional Council may be looking at in terms of the National Policy Statement for Urban Development. So we'll just give some background information on that. There was a discussion in reference to a 2018 infrastructure report, so I think it might be useful to include that as part of the written right of reply. And we would also like to just provide some commentary on the future development strategies which will be required to be prepared by council under the NPS as well. So we'll just provide a little bit of commentary on what council's intention will be in terms of how those future development strategies are prepared and what they'll set out to achieve. Next topic is co-housing. So we had submissions in terms of recommendations to provide for co-housing opportunities within the fuzz areas. It was really useful to gain some further insight into what co-housing is and I guess the driving factors for that. My reflection on that is, given the issues of housing affordability and the new policy settings at a national levels, new ways of approaching housing supply and models of residential living are to be encouraged. It also appears that the economics of securing land and or buildings for co-housing opportunities is a significant challenge, and there was evidence from the submitters in that regard. Anyway, I think the issue for enabling co-housing within the fuzz zone is that the form and nature of the development may well be difficult to reconcile with the overall purpose and function of the fuzz zone. It was noted from the material presented as part of the hearing that a co-housing development may include up to 20 dwellings. And in my opinion, depending on the location or servicing requirements of any development, this may affect how future urbanisation can occur within any given fuzz area. So I think there is a tension there between, I guess, the desire and the merits of providing for those co-housing opportunities and what the overall strategic intent and purpose of that fuzz zone is trying to achieve. In my opinion, it would appear that co-housing opportunities would be more aligned with the existing residential zone provisions. However, again, it also appears from the evidence and submissions given that there is a real issue in terms of the costs of land and buildings and the economics of being able to develop co-housing within the existing residential areas. I just also note that within the existing fuzz zone provisions, multi-unit development, which is essentially what a co-housing development I think would fall under, based on the rules as notified, would be assessed as a non-compliant activity, and that non-compliant activity status is supported by the objectives and policies of the fuzz. Next topic is just consequential amendments and changes, and we've heard a little bit about that from the discussion from today and also through the hearing. There will need to be a full evaluation of the consequential changes necessary to align the fuzz with the other zone chapters, and that includes specific reference to the rules from the rural production and rural lifestyle zones. So that's going to cover, for example, matters such as the goat provisions. There is some of that overlay area which affects the fuzz area out at Oakura. And obviously also in terms of consistency, how the plan addresses buildings and structures, there will have to be consequential changes through the fuzz zone, and also in terms of the references to the intensive indoor primary reduction, or wherever that particular definition lands, that will also have a consequential need for amendments to the fuzz provisions. Lastly, just in terms of some comments, one thing that struck me through the hearing last week was that in relation to the submissions from New Plymouth Airport, that those submissions actually extend across a wide range of zone provisions, and they'll be considered through multiple hearings. And we obviously have the hearings that we've had the hearings on the area Q. Those submissions also relate to the structure plan areas, the rural zone, the airport zone, and also the noise chapters of the proposed district plan. So I just wanted to note there that there will need to be some attention given to the overall coordination and assessment of the plan provisions, just to make sure that there's a consistent approach across all those recommendations and those various zone chapters and overlay chapters, I guess, that will occur at the end of the review process. I noted there that we'll be hearing from iwi and Hapu on Area Q, and we've had those hearings now, so we'll be coming back to the commissioners on that. The spatial extent and land supply, again, that will also need to be further examined as part of the rezoning hearing. And my last comment here was just, I think the fuzz areas will need to be critically reviewed over time, and in my opinion, the fuzz zone should not apply to areas unless there is a very clear path to an urbanisation outcome, because that zone is setting up a clear expectation in terms of a future change to an urban form, and that obviously affects people's aspirations and what they do and don't do on their property. So I think there will be, once the proposed plan provisions are made operative and settled, then there will be further steps that council undertakes in terms of further analysis and assessment of those areas, and that will come through the housing and business assessments, but also some of those other matters such as the future development strategy. So we may well see some further changes to those areas over time. I don't think they're necessarily static planning provisions for the term that they have set out in terms of that the 10 to 30 year time frame for that long-term land supply. So those are the comments, commissioners, that I wish to note in terms of the verbal right of reply. Happy to answer any questions and obviously expand on those in terms of the final written reply.
Yeah, just before going to Kit, I've got an initial, I suppose, comment back. Do I take it you're volunteering to sort of do that? Look at the airport issues across the board. Obviously, you've been involved in a few of them. Kit and I have been involved in all of them too. I think the noise, the airport zone, the rural, the structure plans, the fuzz. So yeah, I do agree, Todd, that looking at those across the suite of issues for that area is going to be important. So that was just, obviously you're involved in a lot of them as well, but that's probably a flippant comment. I'll hand over to Kit to see whether he has any questions.
No, thanks, Todd. I agree with you that the allocation of the fuzz zone does set up an expectation. So I agree. We need to be fairly confident that there is a clear pathway towards urbanisation, if not within the life of this plan, then certainly over the long course. So I think that's good. Yeah, I did also note the absence of any other sort of planning opinion on your proposed policy P8. In an ideal world, we would have had a little bit more discussion and debate about that. I do agree that it follows from the strategic directions and setting up a framework for how and when that land may be triggered as a go forward. Just out of interest, there was a decision up my neck of the woods in a fuzz zone, and I mean, similar sort of concept to what's proposed here. We have these, I think they're called future urban zones, and similar concept. Put a foot on them for now. Don't allow the rural to happen, and any sort of subdivision or development is non-complying until a rezoning. There was a case, I think it might have been out Coatesville Way or even Dairy Flat in the fuzz zone, where someone did come along and want to subdivide and put a house there. It was non-complying, and it got fought all the way to the Environment Court. The Environment Court ultimately approved it, even though it was well ahead of any structure plan or anything like that. Is this ringing any bells? Have you heard of this case?
I'm not aware of that case, or it's not ringing any bell at this stage.
Okay, I know. I mean, ultimately, the court came to the view that given the conditions that were on offer and the place where it was and all of that sort of stuff, it wasn't ultimately going to impact upon the long-term urbanisation of the area, and that was the basis upon which it made its decision. So, I mean, I guess all I'm saying is that that illustrates the fact that even non-complying is not a no. It's just a very hard, and you have to make sure that if you're going to go down a non-complying path, that your proposal's got enough features that deviate it from the norm and don't frustrate the overall objective. So I'm just thinking in that context, potentially a P8 policy does create an issue, because if there's an absolute bar on anything pending demonstrating that there's nowhere else to go, it does really create a high threshold for any sort of intermediary use for a relatively long period of time, potentially, for these land areas.
Thank you, Commissioner Littlejohn. Actually, one of the notes I had written down in terms of coming back to you was you were specifically asking for feedback in terms of any risks or unintended consequences of that policy. So that is something that I would like to address in the written reply.
Okay, all right. No, I appreciate that. But thanks, Todd. Thanks for your work on this. It's good.
Just following on, and you made a point about, Todd, that the long-term land, well, we asked you some questions about whether these fuzz zones are potentially in the life of this plan or the longer term, and I think the view we sort of took was that probably not in the life of this plan, but maybe shortly afterwards. So definitely needing to identify areas that the district can grow into and have those, you know, let's say set aside or identified. But you made a comment just there that, you know, that doesn't close the door on some future plan changes if, as and when the need arises, either on a demand point of view or something changes. I did want to ask you a couple of questions about Area R, which is one of the fuzz zones, and it's just over the last couple of hearings we've been discussing the fact that the Airport Drive connection to State Highway 3 is now been designated, and I think I read somewhere that Waka Kotahi are looking to get that underway 2023, so quite soon, and that you've supplied us with some evidence from another hearing that Lauren has been involved in that area, and some submissions, and it seems to me that potentially is an area that might move faster than some of the others. Is that fair to say? And I'm only really basing that around the perhaps some evidence I saw in that resource consent case that might have suggested that, and also the fact that that designation is now underway and does sort of change the infrastructure dynamic in that space. So just any feedback on that?
Thank you, Commissioner. I think very much Area Q, given that it's essentially been an operative structure plan area now since 2015. So within the whole framework of the existing operative plan, it's been seen as a key area for urbanisation and to serve that short-term land development and land supply need. I think through various, for various reasons, the development across Area Q hasn't happened as fast as most of the landowners would have anticipated. And I think Council is committed to actually enabling urbanisation through Area Q. We obviously need to be mindful and to address the concerns that have been raised from iwi and hapu in relation to the protection and recognition of cultural values. So that's going to be a whole nother piece of work. But it seems to me, and again, from the material that I've reviewed in relation to the discharge application, that council was very committed to enabling development within Area Q, and it's trying to do what it can in terms of ensuring that some of those key infrastructure requirements are progressed.
I was really asking more about Area R, Todd.
Oh, so, well, in terms of Area R, I think there is a issue there in terms of how the existing plan rules have set out, and obviously with the provisions as notified, providing this prohibited activity rule with a link to Area R. And if we retain that as is, and then we are also saying, well, the fuzz zones are intended to provide for that long-term land supply, then that puts it into that 10 to 30-year camp. And that just doesn't seem appropriate when we're trying to enable urbanisation across Area Q. So through the recommendations on Area Q, I have recommended that we accept the submission to detach that prohibited activity rule and replace that by a non-complying rule. I don't think we can really do much more than that, because that would raise an issue of scope, unless someone else has obviously asked us to make the rules even more accommodating or enabling of residential development. So okay. I do think there is an issue there in terms of the existing or the notified provisions relating to land supply in Area R and how that links back to Area Q.
And did I read somewhere that this might be 80% commercial in Area R and 20% residential? Is that?
Sorry.
Sorry, go for it.
Oh, sorry, Louise or Lauren may
yes.
have a bit more background on that, so I'm happy to pass it over to them.
Look, I don't necessarily have instructions on this, obviously, but I did represent council at the recent hearing involving the chicken farm in Area R. And I have filed some legal submissions around this, because the panel in that hearing asked us to clarify what the intention was. So the advice that we provided that panel was that the HBCA, Housing and Business Capacity Assessment, indicated an intention for about 20% residential, 80% commercial, but that at this stage no decision has actually been made around the percentage that will be for each land use activity.
Okay.
And it's a bit of a moving feast as each fuzz is developed and as the council keeps assessing its development capacity.
Yes.
But certainly, sorry.
Yeah. Lauren, I was just having a sort of a wider thinking about the quite strong protection of the commercial CBD area and relationship of, you know, a reasonable chunk of land being talked about as maybe future commercial, just how that all works, whether it's far enough away from the CBD, and as you say, no decisions have been taken, so we probably can't speculate too much on that.
No.
Well, Stephen, the policy P7, if Area R has got to go through policy P7, it would, as part of its structure planning, need to demonstrate that it contributes to a compact urban form and vibrant commercial centre. So it would have to do economic analyses, would have to be the foundation, I would have thought.
Yes.
As I understand it, and the council's witness at that hearing indicated that it would, the thought at this stage is that it would be employment land, so not retail and business, you know, like an area where, and I have to confess, I'm not entirely sure what employment land means, but it's not retail.
Okay.
Yeah.
Louise, you had something to add, I think.
Oh, no, I think Lauren's answered it now.
Yeah.
All good.
Okay, thank you.
Stephen, can I just chime? I just while we're still on this topic, in this notion of this P8 and whether to use an analogy from our rural hearing, a goat gets through the fence and wants to make its way up to the park sooner than it's supposed to.
You love goat, Kit.
Oh no, it's so late in the day. From my experience, the sequencing of development, it really is in council's hands, because in the absence of bulk infrastructure, and everyone will look to the council for the bulk infrastructure. None of the secondary infrastructure and land use change and development can actually occur. So council ultimately, because it holds the purse strings, controls where growth goes and when it goes to some extent, doesn't it? I mean, is that assumption correct for the New Plymouth district? I only say that because these multi-headed beasts called public-private partnerships around infrastructure funding are all the rage up in Auckland in order to unlock land sooner than the council can afford to do it. Does the council entertain any of these public-private partnerships where you get a consortium of developers who, stealthily acquire all the land within a future zone, then do their own structure plan and offer to pay for all of the bulk infrastructure to get it up and running sooner?
Do you want me to
I can't answer that question.
Yeah, okay.
I am aware of that having happened.
Okay, all right.
I think Egmont C is a good example of that, isn't it, Louise?
Yep.
Yeah, that was developer-led, and part of Area Q has been developer-led as well. But certainly in respect of Area R, because it's tied to the realignment of Airport Drive, which is a council designation, that infrastructure, will be council-led, and it is that infrastructure that's going to unlock the residential development in Area Q. So while Area Q is zoned residential at the moment, it's almost a deferred zoning until such stage as Airport Drive's realigned and Area R is rezoned. It's very complicated and complex, and it's unfortunate that it's sort of being carried through, but there you go.
And a lot of our other buzzers have got similar situations. Like you just look at Smart Road, a lot of those infrastructure issues, the second bridge crossing, the upgrading of the Smart Road intersection, they will all have to be council led because they're major projects.
Yeah.
Okay. Is that us done, Kit, do you think?
Yeah. I mean, I could make jokes about goats some more if everyone's interested, or we could just
Wily athletic goats.
Well, I'll always associate it with the goat chapter, Kat. I think it's been a education for both of us as we have learned about goats on the Maunga, and yes. Look, I think that is a finish to the hearing. We will close the hearing now. Very appreciative of the inputs from all of the submitters and the staff, and I really like the way the staff acknowledge the submitters have taken time to put their thoughts down and are really openly considering and thinking about the points of view put forward. So that's great to see. Casey, I know I've asked you twice today already, or Sarah, would one of you turn on your microphone and take us through a karakia to finish this hearing, please? Hey, Sarah.
We're about my 10th karakia for the day. Anyway,
Yeah.
Modi order. Anyway, I tai tō muri au kei te puku mahi mātou ko Maria ko Casey. Engari, he karakia whakakapi ki runga, ki raro, ki roto, ki waho, rire hau, pāmarere.
Bye, Murray.
Bye, Murray. Thank you. And we'll say farewell to the next time. Aotearoa. Thank you.
See ya.
Thanks, day, everybody.
Thank you.